Conversation and simple flipping. That's the movement. Hit the like, subscribe, check it. Yeah, for the next minutes of live TV, you stop with me. Got no limits, I'm that vivid, I just kill it. I take records, cut them and make Mona Lisas. Art pieces, I'm that vicious, I'm that sick. Conversation and simple flipping, I'm live with it. A real magician talking ish and painting live pictures. Stop tripping and start clicking the like button. I take news, analyzing, expose crime patterns. For share, remix, comment, you gotta subscribe. Have my numbers through the roof, yeah, spark wild. Thank you for your PayPals and your super chat. Hit the bell, notify when we drop next. Conversation and simple flipping, live with it. Odd pieces of that silks, I'm that vicious. Conversation and simple flipping, I'm live with it. Conversation, because I'm that vicious. Conversation and simple flipping, that vicious. I'm that conversation and simple flipping, we're live with it. Conversation and simple flipping, I'm live with it. Odd pieces of that sick with them that vicious. Conversation and simple flipping, we're live with it. I'm kinda different, yeah. We're live with it.
Yeah, what's up, kings and queens? We're back, and today we're just going to discuss the protection of private information and the access to it by the courts. We're going to do our segue using some of the acts that are found under that act. Section 205, that's when the judge gives a subpoena to anybody to come and testify, either a public person or a private person, to come and testify and give evidence on a certain case in the interest of justice. Now, what we're going to look at is the Promotion of Access to Information Act 2 of 2000. Did you know that this act, by the ratification of this act, when this act was completed, the Human Rights Commission should have compiled a how-to guide on how to use the act. And this how-to guide should be compiled in all languages. It should be compiled in all languages of South Africa, and it should be as easily readable as possible in the most understandable language as possible. And this guide should also be available to all the citizens of South Africa and whoever may require it, whenever they may require it. And this guide should also contain the object of the act. Every year they should give you the address of that information officer, public information officer, that's what they call them, public information officer. They should give you the address, the information of the public officer, even the information of their deputy. The information officer must annually report to the Human Rights Commission how many requests were made for that document, then who requested it, what time, what was the reason, all that. Do you know that the Human Rights Commission should provide us this guide, how to guide? Did you know that? I didn't know that. I just found out when I read it. We're going to use this topic as a segue to our main topic that we're going to be looking at. We're going to look at the news that caused the row this weekend. Everybody was up in smoke, up in flames, talking about this lady must get arrested, and then this was must happen. There's information that she connected with the accused via telephone. But what we know from Spain's evidence, the cellular expert for the guy who was analyzing the downloads, what we've learned from the cross-examination is that it hasn't established if Ntanzi's SIM card was recut in his name or not.
The clarification point that I get is the following. That he bought this at a store, either he bought the two stores, his clothes and everything. It was either Dan's or Markham's in Rustenburg. and the SIM card and the phone came together as one unit. He did buy the SIM card separately and the phone separately. When he bought the phone, they also gave him that 99-cent SIM card, and it was recut in store, either Dan's or Markham's. But he insists that it was recut using his identification document that he produced in store.
I'm also not clear now, because he started with, he said he bought it in store, like as a contract phone. Now he comes with a 99-cent SIM card. That doesn't match.
Doesn't correlate.
That's correct.
We've never said anything about the contract phone.
But that's my point now.
Yes.
A 99 cents, you not record in store. You go home and record it.
No,
Yes.
not necessarily. I don't want to
The
testify.
one in store is for free. I did it last week.
I did it also last week on my phone.
Please.
So we don't go to debate. Understand, man.
Let the witness respond.
Firstly, he didn't even apply a Section 205, which Advocate TT Thobane will explain later in this video. It was established by even Advocate Mshololo that he didn't apply for Section 205. So that means he didn't acquire information from all the four service providers that we have in South Africa. If he had done that, he would have been sure of whose number it is. He hasn't even established if the accused number 5 was recorded under his phone. He doesn't even know that.
Can you tell this court, can you be able to tell this court with certainty if the number allegedly said to belong to accused number 2 was used by number 2 at the time when that call or that transaction was made?
My Lord, I can only mention to the court that number made a call to that number.
So what is your answer to my question?
I can't tell the court. If
it is okuyinamba kasbanibani lokho ngeke ngikwazi ukusho.
Okay. Same with the receiver, with the recipient.
that's correct, my Lord. I can only tell that number receive a call from each other.
Azi omayelana ke ngalokho akwenzile ke.
Yes. And then from your investigation, can you tell this court with certainty if the number read into the record as the number belonging to Mr. Ntuli was recorded or not? If yes, to which address was it registered to?
The number wasn't recorded in his name.
Okokuqala ke inombolo lena ke okuthiwa kwakuyinombolo kalona ubaba uNtuli ibingekho record okanye ibingekho abazange bayirike ngaphansi kwelokho njani ke.
So it was recorded under which name?
I'm not sure, my Lord.
Angazi ke igama elalivelela elibonisa ukuthi ke ilona elarika leyo nombolo okwakuthiwa ke inombolo kababa uNtuli.
From your investigation, you couldn't find that?
That's correct, my Lord.
Okay.
He acceded that he can't say there was anything illegal happening between those calls, and he can't even say he is sure that the person who was calling from those numbers, it was the person that he's claiming they are, because all he did was receive information from the IO investigating officer, and then he commenced with the downloads to analyze them based on the information that they received from the IO. He didn't even do his own further due diligence to try to understand if this number was recorded really to this person, and if this number was really regarded to this person, if it really belonged to that person. What he used was his own software and his and then he also mentioned Truecaller. He also mentioned the database of the traffic system, eNatis, and then he also mentioned some of these other databases that the cops uses to search, to investigate people, to profile people. Now, why did he exclude the data from the ISPs, the service providers, internet service providers. It's a half-done investigation. We also know from the evidence that was led by him that he also conceded that he didn't even come up with a single SMS that says this is the act is being done, or this is them discussing the event, this is them conspiring to commit the act. There's nothing like that. The SMSs that we heard of was SMSs that were coming from Longwe and then Kelly Kumalo to her sister. Why was it easy for them to access those SMSs? It's because their phones were with them. All they had to do was take the phones and download the data that was already there. They didn't have to do any hard work, because if they had went to the service providers, at least now they would be having the content of some of the calls that they are claiming connect the accused to Mrs. Kelly Kumalo. We also know that his evidence is flimsy because he based this investigation on hearsay from Brigadier Gininda. He doesn't know whether Ntanzi recorded his cell phone under his name. He said it was probably done by a family member, and he also now, which gets me worried, because he claims he's a cell phone expert. He says you can't record a 99-cent SIM card inside the shop. That's what he said. And we know that if you buy a phone, as soon as the record laws were implemented, as soon as you buy a phone from a shop, you are forced to record it. They will never let you get out of that shop without that phone being recorded. Now, where does he get the thing of 99-cent SIM card must be recorded at home? Probably he's taking it from the fact that when you just buy the SIM card, they don't care. Sometimes they don't care. They just give you a SIM card and they say you will record it at home. But it doesn't apply when you are buying a new phone. That doesn't apply. They make you record that thing right there, right then. We're going to segue into Advocate Thobane's daily voice note where he's commenting about the same. He's putting the legal face onto this topic of information collection. That how do you effect a search for information? How do you effect Section 205, as they call it?
Basically, Section 205 of the Criminal Procedure Act, it means that, and it works in this fashion, the state, in the form of the police investigative team, must make an application to a telecommunication company to get the records of a telephone number, and such application must be done before a presiding officer in form of a judge or a magistrate who is not involved in the matter. Most importantly, when they confiscate telephones or cell phones from the accused, they need to get permission from the accused. They cannot just take them without informing the accused of their rights and the purpose of them confiscating the telephones. Access to Information Act is when a member of the public wants some documents from the state. And through that act, an application must be made by a member of the public to a specific government institution to access that information. And it will be determined whether that information is classified or not by that specific department. And there is a time frame governed by the Act after how long the information must be given to the applicant, who is a member of the public, or if they don't want to give the information, they must give reasons why such information cannot be given. This application is not done through the courts. You apply directly to a specific public institution. Thank you. I want to add and say there is too much shenanigans in this case. It's like they're playing chess games on this matter in the High Court, the case 636. There is a lot of breaking news that will come of this matter from tomorrow. You must know that with regard to the affidavit that Kininda read it on record, it is a catch-22 situation. I'll just leave it in that way in order to intrigue the public what I mean when I say it's a catch-22 situation. But it doesn't need a scientist to figure that out.
Now, as I was looking through the internet today, I found out that a J50 is a J50 once it is signed and it has been executed. The magistrate has signed it. That's when you call it a J50. But just an application to like have somebody arrested, the application to a judge to have somebody arrested is just an application. It's not yet a J50. This was also reinforced by a lawyer who was on Bramadenzo's show on YouTube. He reinforced that idea that a J50 is not a J50 as long as it's not signed by a magistrate. So let me not waste much of your time. Please subscribe, like this video, share and comment. Also hit the notification bell so that when we drop, you are in the loop. Peace.